the record. Time is 10:38 a.m.
All right, Mr. Glidewell, we'll go back to Exhibit 6, which is your email to Mr. Riley and others.
Okay.
In that email, you state that Nipper's the only sitting commissioner who is not committed to fight using every dime the county has. Is it your position today that you're willing to fight using every dime the county has?
Objection. That goes to legislative privilege.
I'm not asking you in your capacity as a county commissioner.
Objection. That goes to his legislative capacity. If you don't withdraw that question, we will also ask for a protective order from Judge Green on that issue.
Okay, can move for protective order on that issue.
All right.
Has your position changed with respect to fighting customary use with tax dollars since 2018 through today?
I'm not sure what you're asking.
Well, in 2018, you were telling at least these four people affiliated with the Taxpayers Association that were concerned about responsible expenditures of taxpayer dollars that it's not a good idea to fight customary use using every dime that the county has, correct?
Well, I believe there's a distinction between every dime that the county has and using tax dollars, which, if you're, I don't know which one you're asking.
Well, these are your words. What did you mean by fight using every dime the county has?
I believe the board that was currently in office at the time, they had all stated that they would fight with every dime. I mean, I believe that was a quote. Am I prepared to do that? No. I don't think that's a logical way of doing things. Am I prepared to use tax dollars to fight for the county's position? Yes.
And are you aware more than $2.5 million has already been expended in this fight?
Objection. We're going to move for a protective order.
On what basis?
It's not relevant.
Okay.
It doesn't lead to relevant. It's the same thing,
I'm
same line
saying-
of questions in regards to the Stearns-Weaver customary use invoices, the Theriac and Spain invoices, and the Jim Miller expert fees on that basis.
Thank you, Mr. Theriac. I didn't know if you were asserting legislative privilege or relevance again for that basis, so thank you for the clarification.
Both.
Now it's both?
It is both.
Okay, well, again, thank you for the clarification.
You're welcome.
Since you are following this email in July 2018, have you ever entertained or discussed or mentioned any type of compromise to get out of this CU mess?
Objection, legislative intent, legislative privilege.
I'm not asking you as a county commissioner. I'm asking you as an individual. You weren't even a county commissioner in July 1, 2018, were you?
No, sir.
You weren't until November, correct?
Correct.
Okay. So can you answer my question?
Mr. Safer, just so we're clear, for the time frame, please. Is it prior to him being elected?
At any time without your county commissioner hat on, have you advocated or suggested any type of compromise?
Thank you for the clarification.
You're welcome.
Yes.
Okay. What compromise was that, and when did you advocate for it?
Well, I don't know that advocate is the correct word, but have I discussed? Yes.
And when was that discussion? Who was it with, and what did it involve?
If you're talking about prior to my election, and it was prior to November of 2018, and we discussed a compromise. I believe much like Governor Huckabee had mentioned. I don't remember exactly what he called it. I think it was beach share or something like that. But I had discussions about some form of that, yes.
Did you have conversations with Governor Huckabee about the beach share or some kind of compromise?
Not about his direct program, but I did have a conversation with him about it, yes, sir. Or I believe it was an email stream.
And who else did you have these conversations about the potential compromise with besides Mr. Huckabee?
I don't recall. That was in the middle of the election campaign.
Was it folks only affiliated with the Taxpayers Association?
Not to my recollection. I think I talked about it with others.
When you mean
But
the other?
I don't know. Can't remember exactly who.
All right. Turning back to the first page of Exhibit 6, it appears that Mr. Jason Blakeney with the Northwest Florida Daily News forwarded you the email that we were just looking at and asked you a few questions regarding that email. Is that accurate?
It certainly looks that way.
And then on page 1, you provided your response to that, correct?
That's certainly appears that way.
Okay, and about 3/4 of the way down, it says, in my 4 months in office, I've talked to many individuals on both sides of the issue, and at present, I can see no compromise. Is that your statement as of March 25th, 2019?
Yes, sir.
Okay. And is that still your understanding?
As it sits right now, yes, sir.
And in fact, in your most recent re-election campaign, you took a position on your website that you were to defend customary use, did you not?
I don't think we ever got to the point where we updated that website from 2018 because I didn't have an opponent, so I didn't update that website. But that was my position in 2018.
That was your position as noted on your website?
I'm assuming so, yes, sir.
Okay. All right, let's take a look at what will been marked as Exhibit 5. You can take a minute to look through this exhibit.
Okay.
Do you recall receiving this chain of emails from Governor Huckabee?
Yes, sir.
I think you mentioned earlier you talked about having conversations with Governor Huckabee related to his beach share proposal, correct?
Yes, sir.
Okay. I'm looking at the email. I don't know what page it is, probably about page 7 or 8, dated Friday, July 27, 2018, from you to Governor Huckabee, and I believe we have redacted some email addresses just for privacy standpoint.
Okay.
Regarding House Bill 631.
Yes, sir.
Do you see that?
On page 2?
No, it's about 5 pages in. It's third page from the end, actually.
Okay.
What's the date and time of the email so we can pinpoint it?
Yeah, July 27, 2018 at 5:32 a.m.
Thank you.
You see that, Mr. Glidewell?
Yes, sir.
Okay. All right, and the initial reasoning for Governor Huckabee's email apparently relates to an article where you commented in the Walton Sun, but nonetheless, it's the second paragraph. You talk about the opposition continues to stir this and is going to continue to push farther and farther and to try to catch either Fletcher or I opposing CU so they can hammer us. Why are they still trying to catch you and Fletcher and opposing CU on July 27th if it's on your website that you are supportive of customary use?
You'd have to ask Ms. Jones that.
Who was responsible for creating your website in 2016? Do you recall?
2016?
I mean, 18. Sorry, 18. I don't remember if it was my daughter or I don't remember. Okay, I think you said it hasn't changed since 2018, correct?
No, sir.
Okay. So whoever created it, whoever's operating it now, was the same person in 2018?
I don't think there's been much activity on that website since 2018. But we did pay the bill to keep the address.
So you haven't updated that website to identify any of the top priorities or issues over the 4 years you were in office?
No, sir. I haven't.
Or do you know if any of the 11 items that you identified on your website have been accomplished such that they should be updated?
I
for those 4
honestly
years?
don't remember what they are.
Okay. All right, going back to Exhibit 5. The next sentence states, I am told their polling suggests this is their best avenue to beating us. Opposition to 631 in Walton County polls at around 90%. They know this, so they keep hammering us with more and more outlandish positions. Then you go on to state, I understand that the county ordinance was a power grab, and I think sober minds could have crafted a compromise that protected the rights of everyone. Is that a true statement? Do you believe the county ordinance in 2016 was a power grab?
That's a fair description.
Okay. Why do you characterize it as a power grab? Do you mean a land grab?
No, sir. I didn't mean a land grab. I meant a power grab.
Okay, what do you mean by power grab then?
That persons used were looking for an issue to enable them to continue being in control, and that was a good one.
Okay, so if I'm understanding correctly, that from a political standpoint, opposition to 631 was polling at 90%. Favor of customary use was polling 4-1. If somebody wanted to stay in power as a county commissioner, that issue is one that they ought to continue to pursue or support.
I think that would probably be how most people would view it.
Was that still not the case today with the current commission as opposed to the prior commission?
Not sure. I haven't seen any polling lately.
Well, you're not taking positions on CU based on polling, are you?
No, sir.
With respect to this email, about 3 pages before this, we're looking at an email, again, at one of your response to Governor Huckabee, July 27, 2018 at 8:02 a.m. Say, I appreciate your beach share proposal and wish this had been used as a basis for an agreement everyone can live with. Is that the beach share proposal you were talking about earlier, the potential compromise?
Yes, sir.
Okay. Do you understand or know today what the outlines of that beach share proposal was?
I don't remember the specifics. That was 4 years ago.
And have you not seen this beach share proposal since you saw it 4 years ago?
No, sir.
Okay. And then in the second sentence you say, I also believe fair and aggressive enforcement of the rules would solve many issues. What do you mean by that?
There was the perception that our code was not being enforced, that the rules as they apply to various beach subjects were not being enforced. And I believe, listening to the beachfront property owners, I believe that was one of their serious contentions, was that we the county were not enforcing the rules. And it was my opinion that fair and equitable enforcement of the rules would have prevented a large part of the issues. I mean, you can't let people break the rules right in front of an officer and not enforce them and expect people to have respect for the law.
And has there been any change to the enforcement such that it is now fair and aggressive?
I believe we've made great strides at improving that system.
How so?
Well, when I took office, we had two branches of code. The what we call street code, or the land use code, officers were under the planning director, and the beach officers were under the tourist development council director. In my view, both of that's conflicts of interest in both of them. You got the people who are supposed to be are investigating the problems, working for the people who it's not in their interest to find the problems. So we removed both of those organizations from the who they were under. We created an entirely separate department, a code compliance department, hired an independent director who reports to the county administrator, and his instructions when he took the position were to enforce the law. If the law needs changing, we would change it, but enforce the law.
And does he enforce trespass?
No, because that's a criminal problem. That's the sheriff. But they do enforce the codes.
The county's codes with respect to dogs on the beach, etc.
Dogs on the beach, glass on the beach, the tents, the vendors, we've got the code's about that thick.
What about with respect to when you say enforce the law? Obviously, the criminal law is part of the enforcement on the beach too, correct?
That criminal law is the purview of the sheriff, but the ordinances, which, you know, in layman's terms is the law, but it's actually county ordinances, the land development code, and the beach activities ordinance.
Are you aware if the sheriff has taken a more fair and aggressive enforcement as to the criminal laws with respect to the
I
beach?
have no knowledge of that.
You haven't spoken with the sheriff about enforcement of anything on the
No,
beach?
sir.
Never? Not never, but since July 27, 2018?
Not to my recollection.
All right, moving up to the next email response from Governor Huckabee. After your response, he states, and I quote, if you are quoted accurately, he sends another link to a Walton Sun newspaper. And he says, if you are quoted accurately in the paper, then it's apparent that you flat out lied to me in the email below. I've been in politics a long time at many levels. I'm used to people disagreeing with me and honestly holding a different view. I've never gotten used to people intentionally misrepresenting their position just to get elected. I will appreciate a response. Being elected is more important than maintaining integrity. That is very sad. Would it be sufficient to say that Governor Huckabee believed that you misrepresented your position with respect to CU to him?
I have no idea what Mr. Huckabee thinks.
Well, based on that email?
It reads as it reads.
Did you misrepresent your position on CU to Mr. Huckabee or any other private property owner?
No, sir.
All right, let me show you what's been marked as Exhibit 7.
Yes, sir.
Do you recall this news article that came out in April 7th of 2019?
Yes, sir.
And it was based on the release of the email to Mr. We saw it earlier in Exhibit 5, I believe. Exhibit 6, I'm sorry. Let me find it here. Back in Exhibit 6, it was the email to Jason Blakeney with Northwest Florida Daily News.
Yes, sir.
Okay. And that was the email from you to Mr. Riley and or others with the Taxpayers Association, correct?
I'm assuming so.
Okay. All right, at the very end of the article, it quotes or states that Glidewell said the emails made public were private conversations he held as a candidate and that they were released to embarrass him. Did you recall making that statement to the reporter?
Yes, sir.
Okay. Why do you believe the conversations were released to embarrass you as opposed to make the public known as to the positions you were representing to private property owners?
I have no idea.
Well, you said they were released to embarrass you.
Yes, sir.
Okay. Why do you believe they were done to embarrass you?
Well, because if you examine, I mean, I'd only been in office a short period of time, and there was never any opportunity given to try to work out anything. I mean,
Well, if you saw,
So the only reason to do it would be to hurt me.
well, if you saw the emails, it looked like at least Governor Huckabee and the others believed they were being told that you weren't for customary use. You were telling them you had to put that image out there because of the polling numbers. And then after you got elected, or shortly beforehand, it came out that you were in support of customary use. And obviously they were upset by that. And,
I don't
you know, after that point in time, did you reach out to them to say, let's talk about a compromise?
Objection. It goes to the legislative privilege. He's in office at this juncture.
Okay. Okay. After the emails from Mr. Huckabee prior to your election, this was August, July of 2018. After they sent you these emails basically saying you lied to us, did you reach out to them to discuss?
I don't think those were.
All right, well,
I mean, I don't think that. I don't remember that. My exchange with Mr. Huckabee was in April of 19.
okay.
Now, he did send me one in July
Correct.
of 18, and I explained to him my position, and my position hadn't changed since then. I told them from the front I was for customary use. I had written things on social media since at least 2014.
But weren't you also telling them I'm for customary use in the public because it's polling
That is-
4-1, or
No, sir.
else I'm dead as a candidate?
No,
but
sir,
once I
that-
get in, I'm going to reach a compromise?
No, sir, that is not what I told them, and that is not what I meant. What I told them is that once I was in office, I would try to work out something to fix this problem, and I never changed that opinion. I still hold that opinion, but you got to give somebody a chance, and I don't think they did.
Mr. Safer, it's 11:06. It's another hour that's passed. I'd like to take a brief 10-minute break.
Yeah, that'll be fine.
Thank you.
Good stopping point. So we'll go off the record. Mr. Videographer, you want to say something?
We're going off the record at 11:06 a.m. We're back on the record. The time is 11:18 a.m.
All right, Mr. Glidewell, Commissioner Glidewell, we're back on the record, and I remind you you're still under oath. Turning back to, let's jump to Exhibit 15, if you will. Turn the microphone on. Did you catch all that?
This one?
Yeah, the big thick one. Okay, we talked about it earlier that this was the notice of intent that was adopted by the board right before you joined that initiated this customary use process and lawsuit that we're in today, correct?
Yes, sir.
All right, and attached as Exhibit A is a laundry list, 37 pages of property parcel ID numbers that the county is attempting to establish customary use upon. Correct?
I assume so.
Okay. And then Exhibit B says that within Exhibit B are the sources of evidence that the county commission would rely upon to prove a recreational customary use is ancient, reasonable, without interruption, and free from dispute. Have you personally reviewed any of the sources of evidence in Exhibit B?
No, sir.
Have you personally discussed with Dr. Miller or any other potential witness regarding the evidence to establish customary use in this case?
No, sir.
When did you first hear of the term customary use?
Don't really know for sure.
Well, obviously, you had heard of it in 2018 when you were campaigning because it was a big issue, right?
Excuse me, yes, sir.
Okay. So prior to the county adopting that ordinance in 2016, had you heard of the term customary use?
I don't know. I don't recollect one way or the other. I'm sure I had, but I don't know.
Okay. All right. What is your understanding of what customary use is?
Well, I'm not a lawyer, so I'm not. I can't give you. I can tell you what I think, which is that it's the public's normal usage of the beach, as regards to recreational activities.
Is it your understanding that customary use is limited only to beach parcels as opposed to any other type of land?
I've never heard it associated with anything else.
So you've only heard of customary use being associated with the beaches here in Walton County?
Best as I can recollect, yes, sir.
All right. Are you familiar with the terms ancient, reasonable, without interruption, and free from dispute?
I've heard them.
Okay. What is your definition of ancient?
Check to the form.
You can answer.
I'm certainly not a lawyer, but I would assume ancient means old.
Okay. How old?
I guess that's open to interpretation. I don't have a date.
You don't. Okay. So ancient to you means just old.
Yes, sir.
And you would agree with me that 100 years is old?
Yeah, I would think 100 years is old.
Okay. 200 years is old?
That's older.
Oh, okay. So at least 100 years is old, and anything beyond that is older?
That's fair. That's fair. Some days I think 10 years is old.
So would you agree with me that what is ancient really depends on the person defining it?
I'm sure there's a legal term, but I don't know what it is. I mean, I'm sure there's a legal definition, but I don't know what that is. But
You're sure there's a legal definition of the term ancient?
well, I'm assuming there would be, but I don't know. I'm assuming that old means old.
Do you know that some of the larger issues in this case revolve around what ancient means or doesn't mean?
I would think that that's something for the judge to determine.
All right. What about without interruption? What does that mean to you?
Check to the form.
There again, I don't know what that means legally. Without interruption means without interruption. I mean, it means without interruption.
Okay. And you stated earlier, you testified that you'd go down to various beaches, Blue Mountain, Grayton, and others when you were a teenager, utilize the beaches for various activities. Have those uses been interrupted from the time you were a teenager to now?
Check to the form.
I'm not sure what If you're asking, do I do it on a daily basis? No, sir. If you're asking, if I wanted to do it today, could I? Yes, sir.
So all of the very same uses. For example, you said you drove on the beach, and you didn't personally drive, but you rode on the vehicle.
I may have seen it a time or two.
I've seen it a time or two. Certainly, driving on the beach in that area of Blue Mountain Beach is not allowed anymore, is it?
It's only allowed in Grayton, to my knowledge. But there is a place in Inlet where we could open it back up.
Yeah. So at least driving on the beaches of Walton County, with the exception of Grayton, has been interrupted in the sense it's not allowed anymore, correct?
I guess that's, it's not allowed anymore because the law's changed.
All right. Is there free from dispute? You would agree with me, would you not, that there is currently a dispute regarding the use of the Walton County beaches by the public?
I'm not sure if if that's legal or not. I guess there's some form of disturbance.
Well, if there was no dispute, the county wouldn't be suing 1,194 people, would they?
Object to the form.
I think that's something for the judge to determine.
Well, I'm asking you. I mean, if you didn't think there was a dispute regarding the ability of the public to use...
there's a court case, yes.
Okay. Let me finish because she's taking this down. So, if you didn't think there was a dispute, then there shouldn't be a lawsuit with 1,194 landowners involved, should it?
Object to the form.
I think that's why we're here.
Yeah, and in your email, one of your emails earlier, you said you believe a large number of the issues could be resolved through aggressive enforcement and something else. I forget the other word. But apparently through fair and aggressive enforcement of the rules. That so-called fair and aggressive enforcement of the rules since 2018 hasn't resulted in the resolution of that dispute, has it?
Object to the form.
Well, I'm not sure if it hasn't helped. I'm not sure where we stand now. That's, I guess, to be determined.
What do you think? The dispute has been resolved yet?
It hasn't been resolved because we're sitting here.
Okay, and then with respect to the other element of customary use, reasonable. What's your definition of reasonable?
Object to the form.
While I'm not sure about the legal definition, to me, reasonable means that individuals with common sense would apply the standard.
Okay, let's turn back to page 1 of Exhibit 15 there. And in paragraph 2, the formal notice of intent actually identifies all of those 9 items both you and I could remember earlier. It says the detailed, specific, and individual uses of the parcels of property to which a customary use affirmation is sought are as follows. When traversing the beach, sitting on the sand, in a beach chair or on a beach towel or blanket, using a beach umbrella that is 7 feet or less in diameter, sunbathing, picnicking, fishing, swimming or surfing off the beach, placement of surfing or fishing equipment, and building sand creations. Do you know how the 7-foot limitation on the beach umbrella was derived at?
I have no idea.
What do you think? The use of beach umbrellas has been ancient on the beaches of Walton County?
Object to the form.
I don't know, except I've never used a beach umbrella down there in my life, but other than that, I don't know.
And did you see any other beach umbrellas when you were down there?
Oh, I've seen beach umbrellas down there.
Okay, have they all been 7 foot or less?
I have no idea.
Okay, well, what makes a 7 foot umbrella a customary use as opposed to an 8 foot umbrella?
Object to the form.
Do you know?
I have no idea. I really don't.
Yeah, okay, because, you know, if under the doctrine of customary use, if the use has been ancient for 100 years old, my question is is it just 7 foot umbrellas that have existed for 8 years, or bigger umbrellas existed for that 100 years?
Object to the form.
Any knowledge on that?
I have no knowledge.
All right, and then the last one is building sand creations. Okay, have you seen sand creations been built on the beach?
Yes, sir.
Okay. Kids digging holes in the beach?
Yes, sir.
Okay. Do you think kids digging, or adults digging for that matter, holes in the beach, or not holes, but holes and leaving the holes open without refilling them, do you think that's reasonable?
Object to the form.
I believe that's against the beach activities ordinance.
That may be, but do you believe digging a hole and leaving it open is unreasonable?
Object to the form.
I would say that it's probably not very healthy. It's dangerous. So that would make it inherently unreasonable.
Okay. Yeah, and is there anything in the county's notice of intent that protects a private property owner from any type of liability from members of the public coming onto their dry sand beaches and digging a hole and leaving it open, causing potential injury to others?
Object to the form.
I have no idea.
Okay. Are you aware if the county has purchased any beachfront property over the last 5 or 6 years?
Yes, sir.
Okay. How much property have they purchased over the last 5 or 6 years? Do you know about?
Are you talking about
Beachfront
Are
property.
you talking about dollar amount or land size amount?
Both?
I don't know the exact figures. We've purchased several $1 million worth.
Okay. When you say several million, more than 12? More than 20? I'm just looking for a ballpark.
I don't know the exact figure. I mean, one parcel was $9 million, so
And that was a recent purchase, wasn't it?
that was this time last year.
Okay. All right. And then I'm going to show you an article regarding, I believe, that very property. That's Exhibit 12. Actually, it's going to be a composite Exhibit 12.
Thank you.
Counsel, what was the number of this exhibit?
12, sorry.
Thank you. All good.
Yeah, in composite 12, there's 2 portions to it.
Yes, sir.
All right, this is an article from Northwest Florida Daily News, published December 5th, 2022. And you were almost right on the money a year ago. Discussing a $9.5 million purchase of Eastern Lake property. Is that the purchase you were talking about earlier?
Yes, sir.
And it appears to be a approximately 3 acre parcel of property.
Yes, sir.
Okay. And why? What's your understanding of why this property was purchased?
Well, it was, or is, the outfall to Eastern Lake, so it's a environmentally sensitive piece that we would like to protect, and we felt that that was a something that we wanted to preserve.
Okay. And if you look at the very last page of that composite exhibit, it's an aerial from the Walton County Property Appraiser's website,
Yes, sir.
and it has 3 boxes there on top of the Eastern Lake outfall.
Mm-hmm.
And I believe the 3-acre parcel is the lower right square box. Is that correct?
Yes, sir.
Okay, so that's the parcel of property you purchased for, the county purchased for $9.5 million?
Yes, sir.
Okay. And you're saying it was purchased solely for environmental reasons?
Not solely, but that was a big reason.
Is there any plans to put beach access or parking or anything else on that parcel?
Objection, legislative privilege.
Are you aware of any plans to put parking or beach access on that parcel?
Well, there's already a beach access on our parcel to the north, and I'm not aware of any parking plans.
Are you aware of any concepts or ideas to build some kind of walkway or bridge, pedestrian bridge from your parcel in the north across the parcel that you just purchased?
Object to the form.
The plan, the only plan I'm aware of is to build some bathroom facilities on the uplands.
And are you aware of any other beachfront parcels that the county has purchased for beach access along Walton County?
We purchased, we purchased property. I can't tell you the exact ones out of hand, but yes, sir, we purchased beachfront property.
Well, what is your understanding of why you're purchasing beachfront property if the county already has customary use on that beachfront property?
Object to the question on the basis is a legislative privilege, and I'm going to move for a protective order if you require him to answer it.
Based on his understanding?
Yep.
Okay.
Can the court reporter drop into the chat what we're looking at, please?
It should be Exhibit 12. That's it.
Mr. Theriak, this is Kate Simpson. I've been looking at the case law on the legislative privilege, and the only Supreme Court case that addresses it talks about state legislative privilege, and it certainly does not extend to facts or anything else that the legislators are aware of. And so if you have something that's broader than that, could you please put the citation into the chat feature so that the rest of us can be apprised of the basis for these legislative privilege objections?
I'm not using Zoom, so I don't have the ability to put anything in chat. I did email.
Okay, well, if you
If you let me
email
finish,
that,
please, Ms. Simpson. I did send an email to Sandy this morning with a copy of a motion pertaining to the legislative privilege for a county commissioner, and I provided the court order out of Franklin County. My motion contains the cases that are cited throughout Florida. And if Sandy can email...
That's fine. If you will
if,
send it to the rest of us, that'd be great.
No, I'm not going to do that.
And you're not going to do that, why?
Because I'm in a deposition right now.
Well, I didn't say you had to send it right at this moment, but you've objected to questions that I've asked on that basis yesterday.
That's correct.
I'd like to be apprised of the basis for the legislative privilege you're asserting.
Well, maybe Mr. Sanborn can email it to you while we're sitting here.
If he's on the Zoom, then that's fine.
All right, are you done? Are you done, Kay?
Yes.
Okay. All right. Thank you. And so my question was, goes to your understanding, Mr. Glidewell, of why property is being purchased by the county with respect to beach access if customary use already exists. And your counsel objector, are you maintaining your objection
Yes,
on
I am.
privilege? Okay. All right. So you're not allowed to answer that question right now. We'll deal with that on a protective order basis. All right, let me show you what we'll mark as exhibit, or what's been marked as exhibit 9. This is a email that's been produced by the county, and if you go to the very last email on October 14, 2020, who's Teresa Lowry?
That's my administrative aide.
Okay, and it appears that she had emailed somebody stating that you would like a copy of Mr. Theriak's contract regarding customary use. Do you recall that?
Yes, sir.
Okay. Why were you asking for a copy of Mr. Theriak's customary use contract?
Wanted to look at it.
For what reason?
I believe I had a question about the Mr. Theriak's participation in a land use situation that was, in my opinion, adverse to the county.
Was there any kind of conflict waiver in that situation?
I don't know.
You didn't get any resolution on your questions?
I was assured by the county attorney at the time that everything was okay.
And that was Ms. Noyes?
There's noise.
And that was the end of the inquiry and discussion? As far as you're concerned?
That's all I recall. Yes, sir.
Okay. But Mr. Glidewell, with respect to your legal history, have you been involved in any lawsuits previously? And I say involved in meaning a plaintiff or defendant, not just a witness or anything.
I'm sure I have.
Are you aware? Are you currently a plaintiff or defendant in any lawsuit?
Yes, sir.
Okay, which lawsuit?
Anything to do with the county. I'm in my official capacity. There is one I'm being sued as an individual, which is Maxwell versus Walton County.
And is that Maxwell versus Walton County? Is that the prior county attorney?
The
Or
assistant
county attorney.
Yes.
Okay, that's that lawsuit.
Yes, sir.
Okay. Any other lawsuits you've been involved in your individual capacity?
In my individual capacity?
While you've been at the county, yes.
That's the only one I remember that I'm in my individual capacity.
Okay. And then, aside from your capacity as county commissioner, have you ever been sued or sued anyone in your individual citizen capacity?
I've never sued anybody. No.
You ever been sued?
I may have had one or two that about health bills back in the past, but I don't. Been a long time.
Okay. And have you ever been, and these are questions I just got to ask, all these questions are my job, so
Yeah.
I've got to ask them. Have you ever been accused of or convicted of a felony?
No, sir.
Okay, I don't have any other questions right now. Other council, do y'all want to take a brief break and y'all figure out if you have any questions? But if y'all have any questions, y'all can jump right into them. As far as I'm concerned, David, is that okay with you?
We're coming up at noon, so I'm going to want to take a break for lunch, unless somebody's going to be short and we can wrap it up.
Well, yeah, let's see how long this goes. With respect to council on the call, why don't I just kind of run through these just so you can have a little bit of order to this. Will, are you going to have any questions?
I have no questions of Commissioner Glidewell. Thank you.
Okay. Kay, I know you're going to. I'm going to skip you right now. Stephen Tatum, are you going to have any questions?
We have no questions.
Okay. Alan Levine, any questions?
No questions.
Okay. Going on. Alex Andre, any questions?
No questions from me.
All right. Moving right along. Bruce P. Anderson, any questions from you? Bruce P. Anderson, you're on mute. Or maybe you're just not there. Well, moving on. Glenn Burhan, that's the county. Kevin Wheeler, no, any questions from you?
Kent, I'll discuss them with you off the record
All right.
and let you proceed.
Okay, thank you. So, Kay, back to you. You'll probably have some, I figured. Any estimate on how long you've got?
I do have some. I don't think they're going to take that long. I'd say 15 or 20 minutes. But, sometimes it depends on the answers. But
All right, well, let's jump into those real quick then, and then we'll stop after Kay and figure out if there's going to be any further questions and go from there. Is that okay, David?
We'll see if she goes long, then I'm going to stop it so we have a lunch break.
Okay. Okay, go ahead, Kay.
all right, thank you. Good afternoon, Commissioner Glidewell, or at least it is here in Tallahassee. I guess it's still before noon where you are. I think you said earlier, I represent Edgewater Owners Association and a number of condominium owners in this case. You're familiar with Ms. Harris, the president of the association, aren't you?
Yes, ma'am.
She was on your election committee in 2018, wasn't she?
I didn't have an election committee.
You had a number of meetings at Edgewater with a number of your donors, correct?
Yeah, I had some meetings there. Yes, ma'am.
And at those meetings, you told the people who were present that you were not in favor of customary use, didn't you?
No, ma'am.
In fact, you told the people at the meetings at Edgewater that you were in favor of private property rights, didn't you?
I am in favor of private property rights.
And you told the people at those meetings that customary use would be like people from the south going up to the north and saying that they could hunt on the owner's property because the Indians did, didn't you?
No, ma'am, I didn't say that. It may have been said at one of those meetings by someone else, but I didn't say it.
And if there are witnesses to your statement, to that statement being said by you, then in your opinion, they would not be telling the truth. Is that correct?
I would say we had a misunderstanding.
Now, when you provided security services at Edgewater, what hours did you generally work?
Generally 6 p.m. to 6 a.m.
There would generally not be too many people on the beach between 6 p.m. and 6 a.m., would there?
I don't have any recollection of any crowds being there.
All right, well, when you provided your security services, you were supposed to walk around the property, including going down to the boardwalk and looking at the beach, correct?
We did walk on and kept people off the boardwalk. We didn't go on the beach, to my recollection.
You didn't observe the beach during the time period you provided security services?
We looked at the beach. I mean, it's hard to miss the beach when you're on the boardwalk, or it used to be. I haven't been there in a long time.
Right. If you're on the boardwalk, you can see the extent of the beach in front of Edgewater, correct?
Yes, ma'am.
Did you ever have to assist in removing people from the beach?
Not to my remembrance.
Where did you stay when you were at Edgewater and not making rounds?
Either in the security office or in the gatehouse.
Okay, in the security office, were there cameras of all placed around Edgewater that you could view?
There were cameras that had various views of the property, yes, ma'am.
And one of those views of the property was the beach, correct?
I don't remember a camera on the beach. I remember a camera on the pool area.
You don't remember there being a camera that had a view of the beach when you provided security service?
No, ma'am. That was 20 years ago, but no, ma'am.
All right, that's a good question. What period of time did you provide security services at Edgewater?
From approximately 1989 to approximately 2002.
Did you state in public that you could not have provided for your family without the money you earned at Edgewater?
Yes, ma'am. Without the money I earned at Special Details, and for a lot of those years, Edgewater was the biggest one. Yes, ma'am.
When you were providing your security services at Edgewater, did you see their sign maintaining that there was a private beach?
I don't remember a sign like that, ma'am.
Did you have discussions with Ms. Harris about the fact that Edgewater had a private beach?
Not to my recollection, no, ma'am.
Have you ever seen the application for the development of regional impact that was filed by Edgewater Development Associates with Walton County?
No, ma'am. Not to my knowledge.
Do you know whether or not that development application provides for a private beach?
No, ma'am. I have no knowledge of that.
Have you ever reviewed Resolution 1982-12, which approved the application for development approval for Edgewater and was incorporated into the Walton County resolution by reference?
No, ma'am. Not to my knowledge.
Okay, so those documents have never been brought to your attention in the course of your duties as a Walton County Commissioner, is that correct?
Yes, ma'am. I don't have any remembrance of seeing any of that.
Have you ever reviewed the final judgment entered in Edgewater Beach Owners Association's favor against Walton County in December of 2009?
Object to the form. You can answer.
No, ma'am, not to my remembrance.
And again, that is not a document that's ever been brought to your attention as a Walton County commissioner in connection with the customary use case?
No, ma'am, not to my knowledge.
At any of the time when you were providing security services to Edgewater, were there hurricanes in the vicinity which damaged the premises?
Yes, ma'am. I believe Opal, and maybe there's 2 or 3 more, but I remember Opal.
Okay. And did you provide security services at Edgewater during the time period that repairs were made from the damages caused by Hurricane Opal?
I don't have any direct remembrance, but I'm probably did.
How often would you generally work at Edgewater during the time period that you worked there?
Well, probably 4 to 6 shifts a month.
Do you recall Edgewater repairing the dunes that were damaged by Hurricane Opal?
I don't remember one way or the other. I remember the parking lot, the parking garage being full of sand, but and the elevator shaft being full of sand. That's about what I remember of that. That was a long time ago.
All right. What other current commissioners are you aware of who worked off-duty security for Edgewater?
For Edgewater?
Yeah.
I don't have any. I'm pretty sure Commissioner McCormick did, but I don't know that for a fact, and I don't know of any others.
Okay. You agree that the beachfront owners own property to either the erosion control line or the mean high water line, correct?
I'd have to see those deeds to know that, ma'am. I don't have any direct knowledge of it.
All right, so in your capacity as a county commissioner, you're not aware of whether the private beachfront owners own the property to the mean high water line or the erosion control line. Is that your testimony?
I don't know specifically which parcels are which. I know that there's some that, or I've been told, I haven't seen the deeds, but I've been told that there are some that own to the mean high water line. There's some who own to the erosion control line. There's some who own to the bluffs. There's some who own to a fixed position. There's several different types of deeds.
All right. As a Walton County Commissioner, do you know what property Edgewater owns?
No, ma'am, I don't have any knowledge of that.
But you are aware that Walton County has a lawsuit against Edgewater seeking to establish customary use on Edgewater's beach, correct?
Object to the form.
I'm assuming that that you're a party since you're here, but I don't know of any of the specific property owners. I haven't looked at the list to know.
All right, are you not aware, as a Walton County Commissioner, that Walton County has sued all property owners on all 26 miles of beach in Walton County?
Object to the form.
Well, I don't know that we've sued all property owners, because I'm fairly confident we haven't sued the state. And
All right. Well, with the exception of the state property and county property, are you aware that Walton County has sued all private property owners on all 26 miles of beach in Walton County?
Object to the form.
I don't have any direct knowledge of if it's 100%, 90%, or what percent. I know that we sued over 1,000, but I don't have any knowledge of specifics.
All right. Assume for me that Edgewater pays to restore the dunes after hurricane damage, maintains the beach after hurricane damage, maintained the beach after the BP oil spill. Do you believe it is reasonable for a private property owner to have to pay all of the expenses of maintenance of the beach for the benefit of the public?
Object to the form.
I think that's the question before the judge.
No, this is the question before you, Mr. Glidewell. In your opinion, is it reasonable for a private property owner to have to pay all of the expenses of maintaining the beachfront property for the benefit of the public?
Object to the form.
As I said, I think that's a question for the judge. I don't have a personal opinion one way or the other.
All right, so your testimony is you don't have an opinion with respect to that question. Is that right?
Object to the form.
My testimony is I think that's for the judge to decide, and I'm not a judge.
Do you have a personal opinion on the issue of whether private property owners ought to pay expenses to maintain their property for the use of the public?
I don't have an opinion on that.
Okay. Do you believe, strike that, do you own property?
On the beach? No, ma'am.
Do you own property anywhere?
Yes, ma'am.
Where do you own property?
In Gaskin, Florida.
Is that a town or the county?
I own in the county.
Do you own property in Gadsden County?
In Gaskin, Florida, in Walton County.
Gadsden. I'm sorry. Gadsden. What type of property is it?
Well, I own several acres of woodland and farmland.
Right? Do you believe it is reasonable that if members of the public, including Indians and other people, utilize your acres of woodland and farmland for hunting and or growing crops, that they should be able to come back and do it on your property today?
Object to the form.
I believe that that's not applicable to them anymore
Why not?
because Indians aren't here anymore.
What about settlers? If settlers in Florida hunted on your woodland acres and planted crops on your farmland, do you believe they should be able to come, the members of the general public should be able to come and do that today?
No,
Go to the
ma'am.
floor.
No, ma'am.
Why not?
Because that's my personal property.
And it's your personal property because you have a deed giving you ownership rights to that property, correct?
Yes, ma'am.
Is there, strike that. Were you present for Commissioner Anderson's deposition yesterday?
No, ma'am.
Did you watch Commissioner Anderson's deposition yesterday?
No, ma'am.
Did you speak with Commissioner Anderson after his deposition yesterday?
No, ma'am.
Did you have a written contract to provide security services at Edgewater?
I didn't. I don't know if the sheriff did or not. I have no knowledge.
You haven't reviewed a transcript of Commissioner Anderson's deposition, have you?
No, ma'am.
Have you reviewed any evidence that shows that members of the general public have used Edgewater's beachfront property from 1984 to the present?
I haven't reviewed any of the evidence about any parcel.
All right. Do you have any evidence that any member of the general public has used Edgewater's beachfront property from 1984 to the present without an invitation?
I don't have any evidence of anybody using anything other than my own personal self.
Okay. Has your own personal self used Edgewater's beachfront property without invitation from 1984 to the present?
No, ma'am.
I'm sorry?
No, ma'am.
You said earlier, I believe, in answer to Mr. Safrit's question, that you had worked at a couple of churches. Is that correct?
I've been the minister at a couple of churches, yes.
Okay, and what churches were they?
King Lake Chapel and First Baptist Church of Liberty.
Have you been a lay preacher at any churches?
I was a associate pastor at Caney Creek Church in the early 90s.
Have you ever had to leave a church because of accusations of theft?
No.
Have you ever had an agreement with any church to pay back money that you took improperly?
No.
Did you attend a church that was also attended by Donnie Richardson?
No. No.
What were the circumstances under which you left the sheriff's office? Did you resign?
I resigned.
Okay. Were you asked to resign?
No, ma'am.
Was there a report done evaluating your department and your supervision at the Walton County Jail?
Up to the forum.
Yes, ma'am.
And that report criticized your management of the Walton County Jail, correct?
That could be one interpretation. Yes, ma'am.
Was there an investigation done by Bill Chapman when he was a lieutenant at the sheriff's office
Object to the forum.
investigating misappropriation of funds at the church?
I don't know what you're talking about, ma'am.
Okay, so the answer's no?
No, ma'am. Not to my knowledge.
I don't think I have any further questions.
All right, I don't think anybody else had any. If you do, speak up. Meanwhile, I've got one question. Mr. Glidewell, Commissioner Glidewell, are you aware of Judge Green's ruling last week relating to federal patents?
Yes, sir.
Okay. How and when did you become aware of that?
I believe the county legal department sent it to the commissioners last week.
Okay, thank you. All right, no further questions. Anybody else online have any questions? All right, nobody online. I think Mr. Theriak has a few.
Commissioner, there was a question about whether 100 years is old. You remember that question?
Yes.
Is it your testimony that ancient equates to 100 years?
No, sir.
Thank you.
Case Simpson, objective form.
Thank you. No further questions.
All right, with that, we'll wrap up the deposition. David, you want to give him his read or write?
Yeah, you have the right to read your transcript to see if the court reporter transcribed your testimony correctly. I recommend that you take that right.
Sounds good to me.
Thank you.
And before we go off the record, would any counsel who does not currently have a standing order like to order the transcript of the video?
Case Simpson, on behalf of Edgewater, we would like to order the video.
Okay, anyone else? Okay.
All right, thank you, everybody.
All right, this concludes today's proceedings. We're going off the record at 12:15 p.m.